Namaste, good morning. Welcome to 115th episode of AAA Weekly Webinar Series. Today we are discussing the rights of operational creditors under insolvency law. May it be resolution process or it may be liquidation process. Last episode, 114th episode, we discussed the discussion paper issued by IBPI. If anyone would like to give us the suggestions so that we can collectively give some suggestions to IBPI regarding the proposed changes. Before that, in 113th episode, we discussed the rights of the dissenting creditors and a lot of judgments were discussed. Similarly, the rights of operational creditors are also very important. And in fact, most of the industry, most of the suppliers of goods and services, they are impacted by the provisions of treatment of operational creditors under a resolution process or under a liquidation process. Therefore, we chose that this subject is very, very important. We would be discussing today relevant provisions under the IBC and regulations made thereunder, and also appropriate judgment at appropriate provisions court. So starting with, we should understand what exactly is the definition of operational creditor under section 5, subsection 20 of IBC. The section says the operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So one, that an operational creditor should be like all debt is owed. We'll come back to the definition of operational debt. First of all, operational debt is the word used in this definition, and it includes the creditor who has taken the assignment of the operational debt or where the operational debt has been transferred to someone. So the word used in this definition is operational debt. Then we come to section 5, subsection 21 of the IBC, which defines operational debt. Means a claim in respect of the provision of goods or services, including employment or a debt in respect of the payment of dues arising under any law for the time being in force and payable to central government, any state government, or any local authority. So that means payment of dues to any, under any law. So we are now very clear that the first of all, it has to be an operational debt, which can be for any amount due against supply of goods or against providing some services. So that would be operational debt. Also the employment. Now the employment can be with respect to the workmen or it can be with respect to the employees. Both are covered because the employment word is used. And then that is the under any law. And that includes the amount due payable to central government, state government, or any local authority. So when we see this, then we also have to see, like under section 53, even the operational creditors are classified into 3 different categories. Operational creditors are classified into 3 different creditors. One, those who have supplied goods or services. Who have supplied goods or services, and that has been classified as other creditors. Under section 53, other creditors. Not clubbed with the workmen, not clubbed with the employees, not even clubbed with the dues payable to government. Now the second category is the dues payable to workmen and employees against services that they have rendered to the company. And the third category is the central government, state government, or any local authority or any other authority where some payment is due from the company under any law. Some payment is due from the company under any law, and that can be any law, that can be goods and GST, that can be income tax, that can be municipal taxes, that can be house tax, that can be service tax, that can be sales tax, that can be trade tax. So all these dues are the dues payable to government, state government or central government. In fact, I'm not using the statutory dues word because the statutory dues word is not defined under IBC ever. It is not defined. However, in the preamble, when the IBC was promulgated, in the preamble some words are used. Otherwise, the statutory dues word is not used. So therefore, we are not using this word. Even I have seen the word statutory dues is not even defined under the Companies Act. So the wording statutory dues is completely confusing. So we should actually use the word like amount due under any law to central government or a state government or a local authority. So therefore, the statutory dues as such should not be used. The money should be payable to any authority under a law. So that is what the definition of the this third category is. I also sometimes feel that where the money is paid to the company out of the tax paid money, like maybe that party A has some tax paid money and party A is giving it to B. That can be share capital, that is a separate category, maybe equity or preferential. Then the second category is the loan. And the loan can be secured or unsecured, so that's a financial creditor. And the third category is, which is disputed as of now, any amount paid for purchasing some article, purchasing some goods, purchasing some flat, purchasing some property. According to my understanding, this also is very clearly a financial debt, which is defined under Section 5, subsection 8, clause F. Section 5, subsection 8, clause F, that is where any money. So my understanding is that any money paid to a company other than share capital, it would be either a secured loan or unsecured loan or advance for purchasing anything. What can be the other reason? Other reason can be security deposit, where the Supreme Court has already held that the security deposits would be financial creditor. Even if the security deposits are not interest bearing, the security deposit would be financial creditor. That Supreme Court has held. So therefore, I am not understanding any other scenario where the amount is paid to a company other than the share capital that will be considered as the financial debt. So any other thing like for against supply of goods, supply of services, tax, any amount payable under law, workmen and employee, that all would be operational creditor. Now, when we see since we are talking about the rights of operational creditor, we also have to see like what are the rights of the operational creditor. And I feel there is a complete confusion into the rights of the operational creditor with regard to Section 24, subsection 3 and subsection 4, that is participation in the meeting of committee of creditors. Operational creditors are entitled to attend the committee of creditors meeting and actively engage in the decision-making process. Let us see section 24, what it says. Heading is the meeting of committee of creditors. Subsection 3 says, the resolution professionals shall give notice of each meeting of the committee of creditors to members of the committee of creditors, including the authorized representative referred to in subsection 6 and section 6A of section 21, members of the suspended board of directors or the partners of the corporate persons. C, operational creditors or their representatives if the amount of their aggregate dues is not less than 10% of the debt. Now, when we constitute COC, the COC is constituted based on the financial debt. When the meeting is conducted, when the first meeting would be conducted, what is the obligation of the IRP? IRP will see the total debt, total claims received in a company. And for example, the total claims received in a company is 1,000 crores. 10% of 1,000 crores becomes 100 crores. Now, out of the 1,000 crores, in case the claims of the operational creditors are less than 100 crore, then probably no representation is required in the COC meeting from the operational creditors. However, in case the total claims received from the operational creditors exceeds 100 crore, then what are the obligations of the IRP? Then he will see that if there is any one party which is exceeding 10%, then that party would be invited for the meetings of the committee of creditors. In case there is no party which has a total outstanding claim which is more than 10% of the total debt, including the debt of the operational creditors, then it is the duty of the IRP that whatever the total claims, the IRP should give them an opportunity to select a representative for participating into the meetings of the creditors. That IRP should facilitate in case the total claims received from operational creditors are more than 10% of the total debt of the company, then they are supposed to represent. If there is one person which is having more than 10%, he will represent. In case other than that person, still there is more than 10%, then the representative of the other also would represent. So there is a possibility that 2, 3, 4, or 5 people also can represent from the operational creditors in case their debt is more than 10%, either individually or in total. If individually, then they are specifically invited to the meeting. But in case collectively, then one representative has to be invited by the IRP, and there should be a selection process who would become the representative. That is the obligation on the IRP, and this is a right of the creditors, operational creditors. In this regard, we actually could find a judgment also. That judgment is from ANCLAT, Appellate Authority, from the Principal Bench, Delhi, and that is the citation is Bhushan Shringarpur versus BK Mishra, RP of Lakeland Chemicals India Limited. So in the CIRP of Lakeland Chemicals India Limited, one Bhushan Shringarke, he actually filed an appeal along with the 3 operational creditors challenging the order dated 19th of September 2022, arguing that the resolution professional failed to comply with this particular clause, like failed to invite the operational creditors in the meeting, failed to participate, failed to have their involvement in the CIRP process. Specifically, the RP did not even issue notices to the notices of the COC meetings to the operational creditors. In fact, their combined claims were more than 10% of the total claims. The operational creditors had submitted total claims of 34 crores, out of which 24 crores were admitted, and even this 24 crores were more than 10% of the total debts. Now, in this case, the issue which was framed by ANCLAT, primary issue was whether the RP was required to issue notices to the operational creditors under Section 24, subsection 3 and clause C. Yes. And when their admitted claim exceeds 10% of the total debt, even though they did not have voting rights, but still, finally, the observations of the court was, the observations of the appellate tribunal was that Section 24, subsection 3, clause C mandates the RP to give notice to each COC meeting, notice of each COC meeting to operational creditors if their admitted claims is not less than 10% of the total debt. This requirement aims to ensure transparency and allow operational creditors to express their views even though they do not have voting rights. The appellate tribunal further referred the judgments in the case of ANG Industries Limited versus Shah Brothers Ispat Private Limited, where it was held that non-compliance of Section 24, subsection 3, clause C is significant and it affects the transparency of the COC decision-making process. The tribunal noted that the RP failed to issue notices and it will be considered as a dereliction of the duty. However, they also discussed the practical impacts. They also discussed that how it actually would have impacted the entire resolution when the operational creditors probably they might have negotiated slightly more amount. And that is, however, finally the decision was given in such a manner that the RP was held responsible and it was considered as a kind of lapse of duty and he was penalized for rupees 1 lakh of rupees. And that 1 lakh of rupees is supposed to be given to those applicants who filed this application. It was not supposed to be given to IBBI or any other Prime Minister fund. Then the resolution plan was considered as accepted because this particular lapse should not disturb the resolution process. So this was the judgment. However, the lesson that the insolvency professional will learn that a process of inviting the operational creditors having more than 10% of the total debt is very important. In case not one person, then the out of the balance also the IRP is supposed to get take them through a selection process and one representative has to be selected. So therefore, in case they select one representative, then that representative will be invited in the meetings of the COC. We have another judgment on this that is also from the appellate authority, NCLAT. The citation is Vinay Kumar Singhal, the resolution professional of PG Advertising Private Limited versus Mahesh Bajaj. Now, in this case, the financial creditor of PG Advertising Private Limited filed an application under Section 7 and resolution, it was only more than 1 crore of the dues. Application was admitted and then the CIRP was initiated. Now, the Mahesh Bajaj was an operational creditor representing 10% of the total debt and filed an application before NCLT for issuance of the directions to the petitioner for providing information memorandum. So he was more than 10%. He was coming to the meetings. He was invited for the meetings. The RP did not did any error. However, he was asking for the information memorandum. Now, the RP took a stand that an invitee to the COC meeting is not a member of the COC. And it is clearly written in the provisions that the information memorandum will be shared with the committee of creditors, not to the invitees, not of course specifically written, but it is only to be shared with the COC members. Now, this Mahesh Bajaj, the operational creditor, wanted that in the information memorandum. So he filed an application which was rejected by the NCLT and he filed an appeal. Now, the basic issue was whether a copy of the information memorandum can be given to the operational creditor. Finally, the court actually observed in this manner that the Mahesh Bajaj, the operational creditor, is merely a participant in the COC meetings. So he is not defined in the IBC or in the regulation as member of the COC. Maybe NCLAT further highlighted that the IBC and the regulations are totally silent about sharing of information memorandum with the invitees who are not members of the committee of creditors. Therefore, the copy of the information is not required to be given to the operational creditor, but the other document, because it was also referred that the Supreme Court has held in the case of Vijay Kumar Jain. In the case of Vijay Kumar Jain, the Supreme Court has held that the documents should be given to all the invitees. Documents which are supposed to be discussed and presented in the COC meeting, that is supposed to be given to all the participants. So that was the discussion. But however, in this case, the appellate tribunal found that the NCLT's finding that there is no express prohibition in the IBC or the CIF regulation against providing the information memorandum to an operational creditor who is a participant, meeting was deemed erroneous and unsustainable. So therefore, the NCLT, in fact, NCLT held that the information memorandum should be given. The RP filed an appeal before the NCLAT, and even the Vijay Kumar Jain case was discussed. And finally, the NCLAT, the appellate authority, held that the documents as mentioned in the Vijay Kumar Jain case of Supreme Court that include resolution plans, but information memorandum, which is a unique document, could not be classified as a document that must be given to COC meeting participants, especially in the absence of such a legislative provision. So these are the two things which are talking about the rights of the operational creditors in the meeting. One is the participation, and the second is whether they can get the documents. As far as the documents are concerned, information memorandum is not to be given to the operational creditors who are coming to the meeting, participating into the meeting. Moving on to the next issue is the mandatory compliances. This is very, very important because everyone is talking about the dues which are payable to operational creditors under Section 30, like the section heading with the submission of resolution plan. These are the mandatory provisions of the resolution plan. In case any of the mandatory provisions are not complied with, then the resolution plan is likely to be rejected by the NCLT or any other appellate authority. So Section 30, subsection 2 says, the resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for the payment of operational creditor in such manner as may be specified by the board, which shall not be less than. Manner has to be specified by IBBI, which will definitely come to the regulations, and which shall not be, even the IBC, the Section 30, subsection 2, clause B says it shall not less than, it shall not be less than the amount to be paid to such creditors in the event of a liquidation of the corporate debtor under Section 53, or the amount that would have been paid to such creditors if the amount to be distributed under a resolution plan had been distributed in accordance with the order of priority under subsection 1 and Section 53. Now let us take an example here. One company is having a debt of, say, 500 crores. However, there may be another 500 crores of capital, but the debt is 500 crores and the resolution process started. Out of this 500 crores, even 300 crore are the operational creditor. When this CIRP started, the one is the liquidation value. Now, the liquidation value of this company is, for example, 400 crore. Now, when we see that the liquidation value has to be distributed according to Section 53, so the nothing is payable to, so everyone would be out of the 500 crores of debt, 300 crore debt are operational creditors. First 200 crore debt are definitely payable before the operational creditor, and if the liquidation value is 300, then at least 100 would be allocated to operational creditor. So that is what is the liquidation value due to operational creditor. However, in case the liquidation value of a company is, say, for example, less than even 200, which is the other than operational creditor, then the amount due to operational creditor in case the company is liquidated would become nil. So the second condition is like in the first example itself, in case the resolution plan which comes and finally which is getting approved is offering something which is more than 300. So nobody can say that when the liquidation value is 300, you will only get equivalent to your share out of the liquidation value. In case the resolution plan is coming for 400, then you will get your share out of 400. Then 400 will be divided as per section 53, and first 200 will go other creditors. And since 300 crore was the operational creditor, so the balance 200 will be allocated to the operational creditors. So liquidation value or the amount offered in a resolution plan, whichever is higher, that is what is mandatorily has to be allocated to operational creditor. And if this amount is not allocated, then the resolution plan would not be considered as legally compliant and is likely to be rejected. So therefore, the very, very important part is that the liquidation value of the company and how the liquidation value will be allocated to the creditors. If anything is finally coming to the share of operational creditor, that has to be provided mandatorily. In case the resolution plan is offering more than the liquidation value, then the amount which is available through the resolution plan, that has to be allocated, and any additional amount which is payable to the operational creditor, that would also be given to operational creditor. They said these are the mandatory conditions, and these are mandatory conditions has to be complied with. Now, when we see the explanation 1 to IBC, for removal of doubts, it is hereby clarified that a distribution in accordance with the provisions of this section, provisions of this clause, shall be fair and equitable to such creditors. Fair and equitable to such creditors. There is a lot of litigation to fair and equitable to such creditors. So we will come to that litigation. For the time being, we have to just keep a track what exactly is fair and equitable to such creditor. Now, the such creditor, it can be operational creditor, it can be dissenting creditor, it can be secured creditor, it can be unsecured creditor. It has to be fair and equitable to such creditor. Now, coming to Regulation 38, which is again mandatory contents of resolution plan under the Regulation 38 of CIRP regulations issued by IBBI. Now, in this case, Regulation 38 says the amount payable under a plan to operational creditors shall be paid in priority over financial creditor. Like in case the total amount payable is, for example, 400 crore, out of this 400 crore, 200 is due to operational creditors, because other than operational creditors, there are only claims of 200. So first, it will be paid to the operational creditors, and then it will be paid to the financial creditor. However, the only condition is that there should be a liquidation value which is due to operational creditor. That means in case we allocate the liquidation value to the all categories of debts, there should be some amount payable to operational creditor, which is mentioned in the section 53 as other creditors. That must be payable to them before any amount is paid to financial creditor. So this is also a mandatory regulation. Now, when we come to the judicial pronouncements on this particular section, like fair and equitable, then the judgment that we recall is Committee of Creditors of SR Steel India Limited versus Satish Kumar Gupta, the resolution professional. So in this case, the Honorable Supreme Court observed that the fair and equitable treatment under Regulation 38 of CIRP regulation involves the resolution plan detailing how it has addressed the interest of operational creditors. But this does not mean proportional payment of their debt. The priority given to the operational creditors in payment over financial creditors does not necessitate the same recovery percentage as financial creditors. The Apex Court said that the percentage distribution to the financial creditor and to the operational creditor is not supposed to be fair and equitable. As long as provisions of the code and regulations are met, the committee of creditor has commercial wisdom to negotiate and approve a resolution plan that may involve differential payment to different class of creditors. The court further actually emphasized that the IBC grants the COC the discretion to accept a resolution plan with operational creditors having no voting rights. This differentiates between the financial and the operational creditors. Even the court said that in Swiss ribbon judgment, noting that the most financial creditors are secured creditors whose security interest must be protected. That was held by the Supreme Court in the judgment of Swiss ribbon. Now, the code and regulations alongside the expert body observations of the legal pronouncements affirm that the principle of equality should not be stressed to treat unequals equally. So first of all, the court says that the financial creditors and operational creditors are not equal. Financial creditors are having rights of the voting power. Operational creditors are not having the voting power. Financial creditors are having priority of payment as per Section 53. Operational creditors are, especially those who have supplied goods and services, are having the lower priority. Therefore, they are not equals. So therefore, the fair and equitable does not mean that the people who are unequal, they should become equal. So this is the category. This category is not equal. So these are different categories. However, basically the objective of the resolving the stressed asset. So therefore, equitable treatment should be accorded to each creditor based on their distinct status and interest. So their distinct status, their distinct priority under Section 53, their distinct treatment under the committee of creditors, their distinct treatment while the claims are being verified, that has to be accepted because this is what is the law. Similarly, the judgment of K. Shashidharan versus Indian Overseas Bank is also saying the same thing again and again. And now we can see some of the judgments of again appellate authority on the similar issues, and that is where I would like to see the latest judgment, not very old judgment, is 18th December 23, Jogeshwar Garg and others versus Mandeep Gujral, RP of Jaycon Infrastructure Limited. Now, in this case, Justice Ashok Bhushan, the chairperson of the NCLAT, actually he said that this is a judgment from Chandigarh bench, and the appellants are classified as operational creditors. They are challenging the approval of the resolution plan of Jaycon Infrastructure Limited, and they are contending that they were treated unfairly. They were deprived of the proceeds under the resolution plan despite their claims being admitted. They argued that the resolution plan's allocation was discriminatory and did not balance the interest of all stakeholders. Therefore, they were saying that this is violating to Section 30, subsection 2, and also Regulation 38, that therefore the issue which was framed in this particular proceeding by Honorable NCLAT was whether the operational creditors were entitled to any proceeds under the resolution plan when the liquidation value payable to them was nil. Additionally, whether the COC had failed to balance the interest of all the stakeholders if the resolution plan has the resolution plan violated Section 30, subsection 2, clause B. Now, in this case, the observations from the NCLAT, from Justice Ashok Bhushan, sir, it actually says that the NCLAT examined the compliance of the resolution plan with various provisions of IBC like 30, 31, and Regulation 38 and 39, and it was observed that the COC has actually exercised their commercial wisdom. They have decided to allocate nil amount to the operational creditors, and this is compliant to the waterfall mechanism because there was no liquidation value was due to the operational creditors. The appellate tribunal further even referred the Supreme Court judgments in the case of SRST Limited and Dharmendra Construction Private Limited, which upheld the supremacy of COC regarding the commercial decisions and clarified that the operational creditors are entitled to a minimum value of liquidation value, which in this case was nil. So therefore, the decision from the NCLAT was that the resolution plan as approved by the adjudicating authority did not warrant any interference. The applicant, being operational creditors, they were not having any liquidation value due to them. Therefore, tribunal reaffirmed that there is no material irregularities in or contraventions in the process or in the process of approval of the resolution plan. So therefore, this particular application appeal was dismissed. Now, coming to another judgment, again from appellate tribunal, cited as Hammond Power Solutions Private Limited versus Sanjeet Kumar Naik, the resolution professional. This judgment is dated 18th of December 2023, and this is a judgment in the case of LML Limited. The LML, in fact, had 6,000 employees. I was the RP in this case, and this company, in fact, was into BIFR. And in this case, the issue was, in this case, the issue was the workers were fighting. The workers were saying that we are entitled to the claim as per the award given by the industrial tribunal. In this case, the industrial tribunal, in fact, the company applied for layoff in 2007. Company applied for layoff in 2007, which was held as illegal by the industrial tribunal. Therefore, the workmen were entitled to their full wages, allowances, and benefits. Workers were saying that the particular award of industrial tribunal should be accepted by the liquidator, and the liquidator should allocate the amount according to that. Now, in this case, the appellate authority says that they are not presently saying that the industrial award is incorrect or correct. They are saying that the workers can file their claim as per the industrial award, but the liquidator will have to consider their claim under the provisions of the IBC or provisions of the liquidation process regulations issued by the IBBI. The distribution to the workmen and employees would not be as mentioned in the industrial tribunal award, but it would be as per section 53. So therefore, the award from an industrial tribunal would not override the provisions of section 53, would not override the IBC. That is a judgment which, and in fact, the decision was very clear that the liquidator is working under the IBC. Liquidator can consider the award, consider the amount mentioned in that. The industrial tribunal's award rejecting the layoff, that should be accepted, but the claim would be accepted under IBC, and the distribution to the workman and employee would be made as per section 53, which is for the workman, it is the 2 years wages, and for the employees, it is 1 year, which has the priority. Everything else will go to the last priority along with the other operational creditors. No other judgment in this case from appellate tribunal, again dated 6th November 2020, which is slightly different. That is the again principal bench, New Delhi, and this judgment citation is brief of the judgment in the Excel Engineering. The judgment is Excel Engineering versus Vivek Murlidhar Dabade, RP of New Fulton Sugar Works Limited. New Fulton Sugar Works Limited, and in this case, the Excel Engineering filed an appeal challenging the 2 orders passed by Mumbai NCLT approving the resolution plan of New Fulton Sugar Mills. The operational creditor contended that the resolution plan was discriminatory because in this resolution plan, the claims were in fact settled discriminatory. Now, how it is discriminatory? Because see, it was a case of sugar mill, and there were claims from the farmers who supplied sugarcane, and there were claims from the other creditors who supplied other goods. Now, in this case, the resolution plan was actually distributing discriminatory to the farmers who supplied sugarcane, and in the resolution plan, 100% of their claims were paid. 100% of their claims of the farmers were paid, but nothing was paid to the other operational creditor. No, in fact, the appellate tribunal observed that this is again a case of commercial wisdom of committee of creditors, which is paramount and generally not justiciable unless there is a violation of the law. Appellate tribunal saw that there is no violation of the law. The fair and equitable also have the commercial wisdom of because it may be fair to someone and not fair to someone, but it is overall fair to the process. So, in fact, the cases like K. Shashidharan versus Indian Overseas Bank and Committee of Creditors of SR Steel India Limited versus Tish Kumar Gupta, all these were referred, and the finally appellate tribunal noted that the COC had unanimously approved the resolution plan with 100% vote. The plan was already under implementation successfully. Therefore, the operational creditors who had not been given because the liquidation value due to them was nil, there is no contravention in the resolution plan. Giving priority payment to farmers, giving them 100% without even 1% haircut, that is the decision, because that is the decision of this SR, means successful resolution applicant, because the successful resolution applicant has to source sugarcane again from the same farmers for the purpose of operations of the company, for the purpose of survival of the company. The SRA gave this resolution that he will pay 100% to farmers and nil to other operational creditors, whereas the liquidation value due to farmers as well as to the other creditors were nil. However, discriminatory treatment, paying higher to the sugarcane, maybe because of their local laws, maybe because of the state laws, maybe the farmers are also having some kind of claim on the operations. So all this taken together, I believe this was a good case to understand what is the fair and equitable as mentioned in the explanation 1 to section 30 of the IBC. So this is a very clear cases where we are trying to find out that yes, very, very important things to discuss. What are the rights of the operational creditors? See, in fact, let us try to understand what exactly the operational creditors are. Now, the operational creditors are the suppliers of the goods and services. In most of the time, the suppliers, they supply goods against a pay order, against a purchase order. In the purchase order, there are terms and conditions which are mentioned. Maybe that an operational creditor is giving 2 months credit or even 3 months credit. Now, the cycle of rotation of that operational creditor is 3 months. Whatever goods he is supplying in 3 months, that is getting due for the payment. So in case he is not getting the payment from the company, he can stop the supplies and he can immediately go for the insolvency and claim the amount. In case the amount is not more than 1 crore, then he can go to the commercial courts. However, the risk of an operational creditor is very, very small. Secondly, he is not giving the actual money to the company. He is supplying goods or services, which also has a profit component. The risk which is being taken by the operational creditor by continuously supplying to the company without even getting the money, that risk that he is taking without any compulsion. So that risk is a very, very high risk that he is taking, that if he is not getting the payment within the credit cycle, then he is taking a risk voluntarily. And however, on the other hand, in case you see that when this project was set up, when this project was being set up, a bank has given 1,000 crores of loan to the company. had this 1,000 crore not been given to the project would not have seen this flight. So that 1,000 crore definitely should have the priority, because see, once you invest 1,000 crore, thereafter, there is no coming back. There is no like kind of driving back. Whereas for the operational creditor, it is only a risk of one cycle of supply. In case there is a default as against the purchase order, he can immediately, if the purchase order says that the payment will be given in 60 days and the payment is not given on 61st day, the operational creditor can go and file Section 9 application, or can give a notice first and then file an application. So therefore, the risk of operational creditors, in case they are continuously supplying without any even getting payment, that is voluntary risk. That is a gambling that some operational creditor is doing. Therefore, that should not be considered as a very big issue in the economy of a country. Rather, all the operational creditors should now think that if the payment is not coming as per commitment, they should immediately reach out to the legal remedies so that they are not stuck up. So then they can find other customers and continue their business. So this is very important, that we should understand why the categories are different. One category is that the giving loan to the company for setting up the project, setting up the business, for working capital. And the other category is that they're supplying goods, because there may be 100 people who are supplying goods to the company. So those 100 people are not taking as big risk as the other people that may be debenture holders, that may be the other than shareholders I'm talking about, that the people who are giving their money, because the shareholder knows that they are taking the highest risk, because they are in fact participating into the profits. Whereas the operational creditors, they are actually supplying goods or services. So they should think about continuing the supply in case there is a default. Rather, they are the first persons who actually will come to know about the credit position, about the funds position, about the fund flow of the company. Workers will know, employees will know, and the operational creditors will know whether the company is presently having an appropriate fund flow or not. So they should be the first one to report the insolvency of the company to the NCLT, and so that the company should not kind of give a loss to many other companies. We are also trying to understand another judgment from Honorable Supreme Court, that is in the case of Pratap Technocrats Private Limited versus Monitoring Committee of Reliance Infratel Limited. This judgment was dated 10th of August 21. So this particular case involves that the Pratap Technocrat Private Limited was an operational creditor of Reliance Infratel Limited, and they contested that the resolution plan approved by the NCLT Mumbai, and they argued that they were not fairly treated in the distribution of funds under the resolution plan and were unaware of the progress and details of the CIRP. Pratap Technocrat says that they were unaware, they were not treated fairly, it was not the fair and equitable distribution. So therefore, whether the case in this case, the Supreme Court in this case, basically again says that the issue is whether they were treated unfairly or inequitably, or the distribution of funds were made in an inappropriate manner. So finally, the observation of the Honorable Supreme Court that, so in this case, they were saying that the total revenue which was received, total resolution plan was 3,720 crores. Operational creditors received 19.62% from the upfront payment. Upfront payment means 3,720. They got 19.62%, but the financial creditors got only 10.32% out of the total upfront payment. What I understand that out of the 3,720, maybe it is a case where the resolution plan is padded up by just adding the future investment, future working capital requirement. So therefore, the court has taken this kind of view that 3,720, and it is not possible that the 19.62% goes to operational creditors and 10.32% goes to financial creditors. Therefore, 3,720 of the total resolution plan must have future investments and future working capital. But this was also held by Honorable Supreme Court that the based on Swiss Ribbon Private Limited versus Union of India, based on other insolvency matters, which has already been decided by the Honorable Supreme Court, the operational creditors were not entitled to the same treatment as financial creditors. The apex court found no merits in the claims, appellant's claim, and it was considered as it was it was not considered as unfair. So therefore, the appeal was dismissed. Now, let me see in case there are some questions. We already have, there are in any fact many things that I wanted to discuss regarding operational creditors. And then I wanted to take you through the, so in fact, the Supreme Court, in fact, commented on jurisdiction to approve. So all this was, now the distribution that we have already discussed, distribution under Section 53, and that is the mechanism that has already been discussed. Judicial pronouncements in the case of judicial, we have already discussed the LML case regarding the Workmen. Now the one thing that I wanted to discuss, that operational creditors can also become secured creditor. When we see Section 53, the priority has been given to secured creditor and not to the secured financial creditor. So if anyone is secured creditor, that means that would be treated on a priority. The secured creditor may be operational secured creditor, maybe financial secured creditor, or maybe secured operational creditor, secured financial creditor will have a parity. It would be having an equal treatment. They would be treated at par. So if there are secured operational creditor and there are secured financial creditors, they would be treated at par. So there may be some cases that the security interest has been created against supplies or against the services also. So these would be completely considered as secured operational creditors. So in this case, I think we can also discuss the Rainbow Paper Limited, where the Supreme Court has held that even the the state tax officer against the Gujarat value added tax, they would also be considered as secured. The Gujarat Value Added Tax Act would be, the dues against that act would be considered as secured operational debt, and therefore this was a judgment which was rejected by Honorable Supreme Court because the resolution plan did not consider the dues payable to Gujarat state tax. When the review petition was filed again in this case, and the review petition decision also came on 31st of October 23. In the review petition, the Honorable Supreme Court, that bench, even said that everything was considered in this particular judgment. This judgment, we still hold this judgment as true. However, the other judgment, which actually came in the case of Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat Limited, which is our case. So that judgment also said that the view given in Rainbow Paper is not right, because see, the waterfall mechanism there is a special place for government dues under the waterfall mechanism. So the government dues are specifically mentioned. Therefore, that was not considered as correct judgment. So in the meantime, the Greater Noida Authority judgment in the case of Prabhjeet Singh Soni, that also has treated the landowners like Greater Noida Authority or Noida Authority. They would also be considered as secured creditors, secured operational creditors. So these are the secured operational creditors. So basically, we are not presently discussing the secured operational creditors, but we are discussing the operational creditors. So on some other cases, when there is no financial creditor, the committee of creditors can be constituted only between the operational creditors under Regulation 16 of the CIRP regulations, and the top 18 operational creditors can form the COC along with the representative of the workmen. So in case the total creditors are not 18, then all the total operational creditors can become part of the committee of creditors. One representative from the workmen and one representative elected from the employee has also to become the committee of creditors. And therefore, this committee will have all the powers as the powers are given under the financial creditors. There is no difference between the powers of the committee of creditors. May it be constituted from the operational creditors, may it be constituted from the financial creditors. So the committee has the same powers and there is no difference. This committee can definitely approve all the resolution plans and can approve all the decisions. Let us see the questions that we have today. So like the question is, first question is from Hari Prasad. The question says the court has given decree in respect of the financial default of a company. The decree holder is treated as creditor. What is the nature of the debt? Is it operational creditor or the financial creditor? When this decree was given, what was the nature of that debt? Whether that decree was obtained against supply of goods or services, then it becomes an operational creditor. If that decree was given against a financial debt, then it will become a financial creditor. Again, his question is, valuation figures and resolution plan are the important documents. Can RP share these two to operational creditors and promoters who are the invitees to the COC meetings? Now, the Supreme Court has said in the case of Vijay Kumar Jain that all the documents should be shared with all the participants, because see, the Supreme Court in fact said that they are not coming for having a cup of tea. If they are coming to discuss an issue, if they are coming to frame a view on the discussions, then they have to be shared with the documents. Now, in case the valuation report is important, and if they are giving the undertaking, then I believe the valuation report also can be given to the operational creditors or their representatives. Or in case the resolution plans are also important, we can also give it to them. However, the specific judgment regarding the information memorandum, because the judgment never said very clearly what all the definition of documents would be, but according to my understanding, the Supreme Court has held that any person coming to the meeting, when the resolution plans are discussion, when the valuation report is being discussed, of course, based on the recent changes in the regulations, where the valuations are supposed to be disclosed to all the members so that the discussions can take place, so that the valuers can be presented in the meeting. The discussions are happening with the valuers, the valuations are being discussed. So if they are participating into the meeting, then they are not coming for having a cup of tea. They should be given these documents, and these documents are important for the discussion. However, we have to comply with that law that information memorandum is not required to be given because of the unclear judgment. One anonymous attendee is saying that if the operational debt is more than 10% of the total debt, the few individual operational debtors have more than 10% and few less than 10%. Whether notice of COC meeting be given to the operational creditors with less than 10% also? I said yes. One, if the total creditors are say 100 crore, operational creditor, and no, sorry, the total debt of the company is 100 crore, and in case we have some operational creditor, which is who are having more than 10% individually, then they have to be invited. Once they are invited, and then we see the balance debt. If the balance debt is still more than 10%, then we actually have to take one representative from them. So there is a possibility that there will be 3 representatives or 4 representatives in a COC meeting. One, individually those debtors who have more than 10%. Then those like a cluster, that class of creditors who can appoint a representative in case total debt would be more than 10% of the total debt. Now, the other question which is coming from anonymous attendee is land value of a company taken into consideration for working the liquidation value, since some owners only want to sell the plant and machinery but not land? It is not a question of owner, it is a question of ownership. If the company owns land, if the company owns building, if the company owns plant and machinery, then everything has to be valued and everything will become part of the liquidation cost. Then we have again Hari Prasad ji, he said priority of payment to operational creditors under resolution plan. Is it applicable up to the liquidation value in case the allocation under the plan is more than the liquidation value? whatever is payable to the operational creditor, maybe the liquidation value or the amount, whichever is higher. If the amount payable to them is 0 and the amount which is offered in the resolution plan to them is say 1, then it has to be paid in priority. That is what the regulation says, because section 30 says that you have to pay either the liquidation value or amount offered, whichever is higher, it has to be paid in priority. Mr. Mohit Rana says that there is an ambiguity in section 24, subsection 3, clause C, says that their representatives, section 24, subclause 4 says one representative. So what I'm saying is representative has to be one, but if there is an individual operational creditor who have individually more than 10% of the debt, that will have a separate presentation. And if there are other who are having 10%, but there are many in numbers, they would have only one representative out of all those numbers. Mohit Rana again says in the case of BK Mishra versus Bhushan is pending with Supreme Court for interpretation of law in section 24, subsection 3, clause C. We will see what finally decision will come. But as of today, this is what is coming. Again, the IP.KT says a company is in liquidation, only two creditors. One is FC having 2.5 crores, another is a tax authority having 100 crore of dues as the operational creditor. Liquidation value by the liquidator valuer is 0. Now in auction, company sold for 1.5 crores. Who is eligible to get this money? Also, there is in forensic report of the company and Kufe case before NCLT, it has been mentioned that this FC is in primus of the CD, and to avoid this tax dues, intentionally they take loan of the FC, then defaulted and gone to IBC. By alleging something, the situation will not change. It has to finally decided, it has to be adjudicated. Legally, if a financial creditor is available for 2.5 crore and the total realization is 1.5 crore, it should be payable to the financial creditor, unless the tax dues are considered as secured operational creditor. If these tax dues are considered as secured operational creditors, then of course the amount would be allocated between the secured creditors. But if these tax dues are not adjudicated as secured operational creditors, then it would not be. Then the entire amount would be payable to the financial creditor. Mr. J.K. Das from VOB says, post-successful resolution, can EPFO authorities raise demand on past dues of PF pertaining to employees under Section 7A of EPFO Act? Since such dues are operational dues, are they maintainable for the new promoters? Any judgment in this regard? So the claims of Provident Fund are held to be payable in priority, and that too outside the liquidation estate of the corporate debtor. When we say outside the liquidation estate, if there is any money available, it has to be used for payment of Provident Fund. The Provident Fund under Section 7A, that means the dues which goes to the account of the employees. If there are dues regarding damages or interest, that can still be considered as operational creditor and can be treated separately. But any amount in case given to the EPFO department, it will go to the employee's account. It has to be paid on priority. The claim definitely can come even after the resolution is done. The only thing is that it has to be appealed. Finally, when the demand becomes final, that may have to be paid. But there are judgments from NCLAT that if the claim was not filed the APFO department within the time, then nobody would accept their claim. There is no RP, there is no liquidator. Who will accept the claim? They will go to NCLT and NCLT will reject their claims. So after the successful resolution, there is no possibility that the EPFO department can file a claim. Claiming an amount, and that too through a process of claim, that is possible in case they file a claim, and that too admittable claim. After the resolution plan is approved and it is being implemented, if they come with the demand, that will be rejected by NCLT or NCLAT. Mr. Ranjan is asking what is the case name. I have said all the case names. This anonymous attendee says that in case of distribution of liquidation value under section 53 of IBC, what will be the priority of distribution to the home buyers in real estate cases? So in the real estate cases, the category of the home buyer is unsecured financial creditors. In case of liquidation, the home buyers have to fight that they have a security interest on the specific unit that they have been allotted to. They have to refer to the definition under section 330, 331, 332, 333 of the IBC, and they have to fight out that their claim is secured. They have a lien on the property. Therefore, they would be considered as a secured financial creditor. They have already been considered as secured financial creditor, but the definition, in case it is read in concert with section 331, 332, 333, it would be seen, somebody has to go to the court, it would be seen that the home buyers are also secured financial creditors and they should get at least the value of their property. So the time is up. So there are many questions. Thank you very much. And I'm usually very happy with the questions. But of course, we have to we are all slaves of time. So thank you very much for participating. And this is our way of learning. Thank you very much.